That's going. We're just trying to get the live stream going now. And we want to make sure there's no feedback. Okay. We are live. I'm going to move over here.
Oh, we need to move the camera the other way.
Possibly.
You got it good?
I think so. I'm just going to go around the room and make sure you can hear everyone okay, if that's all right, Jerry.
That sounds good.
Okay, so Nicole Brown, and then go ahead. Ellen Coleman.
Jenny Shelber.
Herb Argenbright.
Dennis Miller.
Yeah, I can hear everybody.
Perfect, okay. Can you turn the laptop up that way a little maybe without compromising the cable? No, towards them. Maybe not.
My
Go ahead, keep turning. Keep going.
We're trying to get it turned so you can see the board members a little better and not just Helen.
Keep turning.
Our live streaming service. There we go. Okay, now we got it.
is that?
I think so. And so can you still see Helen as far as live streaming?
It's actually offline. We just lost. Oh, we had lost connection.
That might just be the internet competing with Zoom
I
too.
might.
Yeah, if you need to move over to the next chair, you can do that too, if that's easier.
Yeah, you're still streaming.
Okay. All right, so we are good and ready to call to order.
If you do a monitor, so you can actually go to live stream and watch on there instead of through the Zoom.
Oh, sure.
To see people.
Sure, okay.
We're all electronically plugged in, so now
Right.
then we can.
I think so. I think that
Okay.
everything is connected and ready to roll. We're still live streaming on there, right? That's the most important part right now. Okay.
You were so busy getting it set up, I see we don't have an agenda though.
No, you don't. No. The only thing on the agenda though is the subdivision regulations. Shoot. They're
Jerry
written
is
off in
the
my
agenda.
office.
Welcome agenda. Okay. So I guess we're in session. What?
So the only topic on the agenda today is the updates to the Broadwater County subdivision regulations, which is why we have invited Jerry Gaventz to attend this meeting and assist us with the amendments to these regulations. Jerry's services are being paid for through the CDBG grant funds that were essentially left over through the growth policy plan. So since there was actually extra grant money left on the table, the Community Development Block Grant is what CDBG stands for. We were able to extend that grant long enough to be able to amend our regulations and continue with Jerry's services to get these amendments done. So that was a really nice surprise for all of us. We never have extra money. So in any case, each of you should have received a copy of the Richland County subdivision regulations. And so I suggest that we just start at the beginning and go through, not reading through these, but I don't know how each of you marked it up. I went through and wrote down the page numbers of places I had questions.
I just marked the pages.
Mark the pages.
I just literally would have to turn through and find my notes in the margin. Some of them were dog-eared, but I guess the very first question that I had was, this thing's so fresh, has it been tested? It's only a year old.
Herb, I can probably chime in on that. To be honest, because Tara DePue at NACO has reviewed and helped Richland County through the development and adoption process, I'm relatively confident that it'll stand up to legal scrutiny. I mean, there can always be litigation, but Tara, along with just a couple other people in the state, is probably one of the best land use attorneys in the Northern Rockies. So can't say that, you know, this version of the regulations has only been in play for a little over a year, but I'm pretty confident that from a legal perspective, it's solid, so,
Well, it looked good, but there were some things that were there that I had questions about if they had been tested, just because they're stronger than ours, there's no question about that. But is it gonna stand up? And then previously talking to Nicole, she had a question in terms of some checklists. I think that'd be a good time. Why don't you just go through yours and then we can feed Jerry all the questions that we can, just
Sure.
one at a time, rather than going back and forth. I think it'd probably be a little more productive.
Certainly, okay. So on my list, I'm just going to start at the beginning of where I had questions. And then is that preferential to you, Jerry, if we each just kind of go through our own list?
yeah, absolutely.
Okay.
That works great.
Okay, so my first question on page 2,
Okay.
this is a really simple question. Under item number 10, it talks about the growth policy plan of October 1, 1999. I assume that that's not specific to Richland County. I assume that that's specific to MCA, correct? So we do not need to put our date in there.
Correct.
Okay.
That all relates back to when the original growth policy statute was adopted. These are the dates that apply to when the growth policy statute was put into play and whether or not you can call them master plans, comprehensive plans. Because the reality is you can call your growth policy anything you want to. You just have to refer back to the actual statute.
Perfect. Okay. I thought that that's what it was, and I could have just looked it up, but I marked it just for questions. My second question comes on page 22. Item number 35. An engineering study that identifies the base flood elevation. So are we going to require that every developer has to do an engineering plan, or is that only if we don't have a designated floodplain area for the county? As in the FEMA firm panel maps?
Right. This is a question that's come up with a couple of other jurisdictions I've worked with this same template, Prairie County and Shoto County. And that probably needs to have a paren saying if applicable. So indeed, if you had a floodplain map, you would probably want to require that. Or perhaps it's a piece of ground that while there may not be any floodplain mapping, you may have evidence that it has flooded, whether it's photographs, firsthand testimony. So that should be an if applicable sort of a requirement. You're not going to require that for every single subdivision. It could be up on a wheat bench or something. Everybody's like, that's never going to flood. If it does, the world's coming to an end. So that's probably one of those that should be an if applicable.
Okay.
Does that make?
Absolutely. Yes. And then, let's see, okay. Well, so then I went down to number 38, also on this same page. And we don't require this currently. But in reading through the regulations, I saw their formulation for requiring this, all instruments of transfer recorded since July 1 of 73. And where did I see that at? I did not mark that. So is this a requirement through the state, or is this just their preference? Is this something that we should be doing because we are not currently?
So my understanding is that's a statutory requirement.
Okay. So we will need to add that. Where did they outline that here in these
What page
regulations?
was that, Nicole?
I'm on page 22,
Okay.
item number 38.
I don't have a 38 on 22.
Yeah. we're trying to follow along and it,
I wonder if, I hope we're using the same version.
So to the board, do your versions have a 1 on in a bold up in the upper right-hand corner?
A bold one,
yeah,
yeah.
Yep, and then the supplement should have a 2 in the upper right-hand corner, correct?
yep,
Correct.
Okay, so you and I are of the same copy, but I apologize, Nicole, I don't know why you don't have, I just wanted to double check that, because I was fairly certain when I sent this out to the board, it should have had a 1 in the, because there's two components to the Richland template, per se, is the regulations, which has a 1 on it, and then the supplements, which has a 2 up in the upper right hand.
Okay, we'll
Yeah.
disregard number 38 then, if you don't have that. I downloaded mine off the internet, off of their webpage.
So let's see.
And I'm sure you probably mailed me one, but in working from home, I was using this one online and formulating my questions. So I think somebody else should probably go, not me, if this is not their most recent version, if they haven't updated their website. I'm going to it here.
well, let's just, if we run across any others, to me, I'd say we just put a little star and then we go back and find.
Okay, so
You
you don't
can
have,
email all of us what 38 was, and then we can see if it matches something else.
okay.
Yeah, I think that's gonna work fine. I suspect that those are pretty minor.
Probably some minor changes that, okay, well. Disregard my question for 38 then, or for number 38. So, page 27.
Well, don't disregard it, just
Well,
make
if
a
you
star
don't-
on it so you can send it to us and we all know what you had a question on.
Right, no, but if you don't have it, if it's
Yeah.
not in this version that we're taking, then I guess there's no reason to waste a lot of time discussing it. Page 27.
Okay.
Oh, this is more of a process question I have, not so much for the regulations, but because I'm dealing with this right now. So the extension, this is regarding extension requests of preliminary plat approval. The extension request is made by the subdivider in writing at least 2 weeks prior to the expiration of the preliminary plat. Is that statutory or is that regulation? I mean, is that just their preference?
So you're talking about section 2-A-6,
Correct.
preliminary plat approval?
Correct, A little 1.
So I think that each jurisdiction can make that decision.
Okay,
And again, the page numbers may be different between what the board is looking at and what you're
and what I
looking at.
have, okay.
Sorry, it's the same thing. So board members, we would be on page 28. An extension of preliminary plat approval period.
And I'm looking at 2A6A1.
Here we go.
Yeah, my approach and understanding is both governments have the ability to determine what that should be. Obviously,
Okay.
it has to be reasonable. And you don't want to just say, you can do it in 3 days or 5 months. So that 2-week period is something you have flexibility on.
Okay. All right, similar question on, still in the same section. So we're looking at 2A6A3. Prior to granting any extensions, so for you it's probably on page 29.
Right.
For me, it's on page 28. Prior to granting any extensions greater than 3 years, they must hold a public hearing. I'm paraphrasing here, but Is that statutory, or is there some flexibility with that also?
That is based on case law.
Okay.
If the Pew was on the phone, it's not statutory from what I understand, but that's case law.
Okay. So it's a good standard of practice.
Yeah, absolutely. And it's also talked about in law, but not specifically like this. So if you go to, not that I'll bore you with statute too much, but 763610, effective approval of application and preliminary plat, it talks about the 3 calendar year, not less than 1 year, what type of stuff, so.
Okay. Let's see, and then I went on to page 41 and 42, so for you it may be 42 and 43. Let's see. What section? Oh, okay, so this, I just wanted a more in-depth discussion or explanation regarding this tract history, because I was having a hard time understanding it and reading through these regulations. So this I have it on page 42. It looks like this, kind of this example. Do you have that, the picture of the parcels being parceled out? And I don't know what page you have it on.
Okay, we have that.
If you're a page
It's
ahead
page
of me.
46.
Oh, you're all the way to 46. Okay. So
Yeah, the version they have has the subsequent minor diagram on 46.
okay. So is this to say that how do I want to say this? So it has the same process as a first minor as long as it's not creating greater than 5 from a tract of record.
Yeah, so this gets confusing. This all stems, and I'll give you a little background because I think it's important, is that in Missoula, Lewis and Clark, Gallatin, Flathead, Yellowstone, before the subsequent minor statute was passed by the legislature, what was happening is people were doing multiple minor subdivisions. You might own 200 acres and you come in, propose 5 lots. It's a minor subdivision. It only has to go through minor subdivision review. You don't have to look at the cumulative impacts. They come in the next year or the year after, do 5 more. That's the first minor. What was happening is people were essentially creating major subdivisions adjacent to each other, and they would only have to go through first minor review and not have to do a larger mitigation for impacts to public health, safety, public services, the list goes on and on. The legislature changed the law to create what they call the subsequent minor, meaning that local governments have the flexibility to decide if you create more than 5 tracts of record after 1973, if you create 5 tracts of record from one existing tract, whether they're subdivisions or exemptions, meaning you have to count everything, family transfers, subdivisions, boundary line relocations. Local governments have the ability to treat those as subsequent minors and review them either as a first minor or as a major subdivision. So that ultimately the commission has the ability to decide in their subdivision regulations if they want to treat those subsequent minors as a major or first. Just because, especially in the bigger counties with lots of subdivisions, they didn't want these little minors stacked on top of each other and essentially being majors, and wanted the ability to address those. Does that make sense?
Yes. Okay.
I don't think it's right, though.
That's kind of tricky.
It's
Yeah.
very tricky, and not only that, it's taken away different people's rights. I mean, he's not making a major. He's making a
Well,
minor.
If it was the same property owner and they did, let's say, 6 minor subdivisions at 5 lots apiece, it really is a 30-lot subdivision by the same person.
If it's the same person, but suppose it's a different person, like Herb sells me a lot, and it's down here, number 4, and I turn it into 3 lots, and Herb didn't do it, I did it. And I should be punished and make it a major?
That's a policy decision that the commissioners get to make, so it's completely up to the county. You have the flexibility to decide how you want to do it. You don't have to treat it as a major. That's why the law is flexible enough. You just have to determine, is it a subsequent? And in the regulations, you have to be very clear. Okay, we're going to treat subsequent minors as first minors, we're not going to review them as majors. The only caveat I would throw out to you is, in the south end of the county, a savvy person is going to figure that out and is going to do a lot of first minors. It's just the reality.
Well, you know what we're looking at this at? We're looking at this as everybody's a criminal. They're coming in here to screw the county. Instead of they're coming in here to actually really make a minor subdivision. I don't like looking at people from the wrong direction, that they're coming in as a criminal to see what they can put over us. And I think and the planning board should be able to look at it and judge. Is that Herb trying to get this by you or Jenny trying to get this by you?
Yeah, I don't think the law gives you that flexibility. I think you just have to make a policy decision and see how it goes. If your recommendation to the commissioners is at least for this go around, see how it works out. If people don't abuse it and it works fine, then you don't have to worry about it. You can always come back and amend the subdivision reg. No problem. Does that make sense?
Yes.
I'm
And
not trying to tell you what to do, it's just the law, it's one way or the other, so.
so currently in Broadwater County, we review all subsequent minors as a major. So even if it's a 2-lot split, if it's subsequent, it's reviewed as a major. And so that's where I was wondering if we were overarching, our power or what have you, by reviewing all of them as a major. We have the ability to review them as a major or a minor if the cumulative impacts have not been met with the 5, correct?
Correct.
So we can stick with this blanket review of any subsequent minor is reviewed like a major. Hopefully, we're right in that. Okay. What else? And if I'm being honest here, I only made it to page 57, and I know you gave us plenty of time, but as far as my notes go, I stopped on 57. Obviously, just minor amendments, replace the Yellowstone River with Jefferson River.
Right.
But that was all I had. And then I had a question which might be addressed in your version of the regulations as far as the weed plan, fire plan, application. Are those a part of the regulations still, or do we keep those as separate, or do we now make them separate documents? Because currently they're appendices in our regulations.
So I am going to, the application, the submittal on page 22 that the board has. Look at this. So in the Richland County template, again, I'm thinking of this as a template, on the board's version, it's page 23. Nicole, it's probably page 24 on yours. It would be number 26 on page 23, noxious weed management compliance plan is what they call it, Richland County. It's in that list right now as something to be submitted, but that's entirely up to the planning board and ultimately the commissioners to decide if they want that or not.
Okay.
Is it possible to turn up the volume? Particularly when Jerry turns his head, I'm having a hard time
I
hearing
think
him.
so. Can you turn it up with the remote?
The volume in
TV.
Sorry
here.
about that, Bert.
Whoa.
Well, it's just, the volume isn't on real loud. and I'm hard of hearing anyway, so I'm just trying to make, is anybody else having a hard time hearing him? If we turn the
And your
volume on the
battery-
TV up, I
battery
think
died, so
that,
yeah, keep going, I think, keep going up a little higher. Okay, we'll try
Okay.
that now. We just turned up the TV a little. You can't see it, but we have you on a TV screen in the room.
So Herb, can you hear me a little better?
yes, quite a bit. That's just like turning up the volume on the TV. That's what I was looking for.
Right, so what I was saying is the weed management plan is listed in the preliminary plat submittal stuff on page, it'd be your page 23, that's number 26, as part of the application list of materials. And again, it's entirely up to you if you want it included as in the list, or if you want to deal with it as a condition of approval. It's really up to you.
So it could be, okay, so that's kind of where I was going with this. Our weed board amended how they review weed management plans, and it takes significantly longer. It's no longer, you don't just fill in an application. I mean, you actually sit down with the county weed coordinator and, you go through and you actually build an extensive plan. So that could be required as a condition of final plat approval, correct?
Right.
Because the way we have it worded now in our regulations, you must have an approved weed management plan before you can even be considered for element completeness, let alone sufficiency. So I would hate to have to hold up a developer from submitting an application on something that, to close that loop and get final plat approval, they're going to have a weed management plan. But if we can hold it off until final, that would just help the developer in the beginning getting through the process. So we could hold it from requiring it for preliminary plat approval.
Yep.
Okay.
I agree. Anything that, as long as you talk about let's say it's 20 acres and it's full of spotted knapweed, and you discuss that fact in the staff report, and one of the findings of facts, conclusion below is there's noxious weeds that need to be mitigated. I think having it as a condition so they can get preliminary plat approval and move along is the best way to do it. In fact, there are probably other things in the list that could be best handled that way, just because it can be really time consuming. As you pointed out, the weed board has a different approach, and there may be other things that it's more efficient for everybody if it's just part of the review and then put into the conditions of approval.
Okay.
Unless, of course, it's like something that's a showstopper, like, hazardous waste dump or something,
Mm-hmm.
that's, off the wall, so.
Okay. I think those are all of my questions currently. If somebody else has more that they want to step into.
Jenny's got a whole bunch of them marked here. I'm gonna take this one out because my battery just died, so I'll have a harder time.
What size battery do you need?
Huh?
313 or 13?
No.
We're trying to get hearing aid batteries.
I think we have the same one.
No worries.
I need some new young blood on this board. If anybody wants, I'm just kidding. I love you all very much.
Go recruit them. I've been turned down twice. I've been going for younger. I tried to get Jessica Crush in here. I told her she'd be less than half the age. She didn't show up
Don't
today.
feel bad, Herb. My middle brother has hearing aids, so it's nothing visual to me.
Oh, thank you.
Okay.
Jenny's like Mary Poppins. She has everything.
Simply blow up an umbrella.
Right.
Oops. Somehow two of them fell out.
Jerry, I do have a lot of questions, and a lot of it is because I don't understand it, and I have two good things in here. One is good. On page 6, the no-build zone. Very good definition. And then back further in the book, when it comes to roads, I have Herb. because I don't understand it, and I would just ask him the questions and he could give me the answers. Otherwise, all of these are for you.
Okay, that sounds good.
Okay. And it's, I don't understand. This will probably have you all in stitches that I don't understand a lot of it, but I just learned what streaming meant today. Okay.
It has nothing to do with water.
I know.
Surprisingly.
I know. Page 15,
Page 15.
B, number 3. Prior to public hearing, they shall put a sign up, 3 feet by 3 feet be readable by 50 feet. I'm just,
So,
you don't have to answer anything, I'll just tell you all this stuff. Page 26.
do you want me to speak to that one on page 15?
Oh, sure.
So, as you list them, I'll go through them. So that's entirely up to the county. Richland County has decided that they want to do a sign posted on the property. That varies from county to county. Some counties do it, some counties don't. That's entirely up to you.
Okay.
If you remove that from the quote-unquote template, you are more than welcome to do so.
Then the next would be page 26. C, 3. Water and septic proposals, isn't that DEQ?
It is DQ, but let's say it's a pretty complex community drain field system that, could be close to a no well system for City of Townsend or somebody else. I think that if you go to the top there, it talks about a material change. If it's a simple change that everybody's like, it's no big deal, it's just practical, it wouldn't apply. But if it's a significant change that the public, even though DEQ and or the county sanitarian would be involved in a review of this, if it's a material, and I hate the term material, substantive change that the general public, or maybe even you as a board member, might be concerned about, that may be a rationale when this is applied. Does that make sense? Again, there has to be a review to determine whether or not it's material / substantive. And maybe there needs to be a definition of what that, criteria is. Does that make sense, Jenny?
Maybe if it had a little something other to it other than water and septic proposals, period, or in this case, semicolon, so that it's not so vague, put it a little more specific. Maybe that's what a lot of these are. As a matter of fact, that's the same thing on page 28, number 3, very same.
Yeah, okay.
And you already did that one.
And Jenny, these are good questions, because how do you determine what a material change is? The property owner subdivider may have one opinion, Nicole might have another, a consultant might have another, you might have another, so.
And then again, most of these are a lot of this on DEQ. Page 40.
Page 40?
Yes, 4. The governing body shall collect public comment on water and sanitation information and shall make any comments submitted on a summary of the comments submitted.
So that is required under the statute. It's kind of a pain. A lot of us don't really like that. So 76-3-622 talks about water and sanitation information that has to accompany the application. Unfortunately, this is language right out of the statute. So it's one of those things that technically the county commission is supposed to consider. So from my standpoint, it would be a lot easier if we could just simply say it has to meet DEQ requirements, but thanks to litigation over drinking water wells and septic system and lagoons, we have this statutory requirement. Does that kind of make sense?
It does if it's a law, but it just seems like to me, like I'm gonna use myself as a example. Do you think I know anything about the water or the septic? I don't even know how many feet it's supposed to be until we look at each subdivision and I look at that particular distances or whatever. Is it pertinent? Is it proper? But like to have it as a general public, do you know anything about the septic systems?
I know some, only because I work with the sanitarium.
Oh, that's right. Wrong person.
General, no.
Wrong person. I'm not going to ask Bernadette or Nicole either.
Can I jump in for 1 second?
Sure.
Herb might appreciate this better or worse. What it is really building the case that either the subdivision should be approved or it should be denied. It's really building findings of fact to support whatever the decision is. Unfortunately, it's in the statute and it's not as simple as DEQ should review this, and if they say yes, it's good enough. In a lot of respects, that's what it should be, but that's not what they're doing. So.
Okay. Do you have an example, Jerry, of it? Because I had the same thing Jenny's talking about there on 40. I had lowercase 2, 3, and 4. I had them all blocked in with just a question mark. Can you give us an example? Because kind of my feel on it is we have a hard time getting public comment. We get 1 or 2 people when we have a meeting. The only time that we get public comment, it's NIMBY. And I don't really feel like NIMBY has a place. We need more definitions if we're going to have something that general in there about what's acceptable. We don't need to take up 30 minutes of everybody's time listening to somebody complain because they didn't read the newspaper.
Right. I can send some examples. Well, actually, I can print them off and mail them to the board of what other jurisdictions are doing. Some jurisdictions call it substantial and credible evidence, and the consultants, the engineers who are working for a subdivider, put together an analysis of the drinking water system and how much water is going to be consumed for domestic use, irrigation, and then an analysis of the septic or wastewater treatment. And maybe what would be good is if I can provide you some examples and there's one that you like, it could be an appendices to the subdivision regulations saying, this is the type of information you need to provide. It meets this requirement. It's clear to everybody what it means. Does that make sense? Yes, no?
More than this. I mean, I don't disagree with what it says. It's just I see it as too wide open.
Exactly, too broad.
And too much public comment that really, in my experience in the last 20 years, probably is not too germane to the issue. It's strictly NIMBY. And how do we level the playing field in there? Yeah, they have a right to complain, but if it's not factual, then it shouldn't be taken into consideration by the commission in terms of whether or not it's going to be approved or not approved.
True, and that's that gets to the heart of why the legislature probably could have made this a lot easier, but you're getting to the heart of why this language is here, is people would come in and say, well, they're gonna use all my groundwater, even though they might be in the bottom of a valley full of alluvium aquifer, which they would make that argument, and the commission or the planning board might feel buffaloed by that and be like, we should probably, put all kinds of conditions of approval on it or say no. One of the rationales for the subdivider providing this information is to rebut that very thing that you bring up, is that the NIMBY comes in and says, well, they're gonna use all my water. Theoretically, the subdividers provided the information to say, there's so much water here, that's not even a credible argument. Does that make sense?
Partially, but to me, it's still something that needs a great deal of work in comparison of this. And I'm not trying to pick apart what they have. I mean, they're up against the oil boom and all that kind of stuff, so they should have more experience that needs to be listened to. I just have a hard time getting my head around this one in terms of how to make it fair.
Right.
That's all. I mean, I'm not saying it's good or bad, it's just how do we understand it or put it in language that is more understandable.
Right. Well, maybe what I'll do is I'm gonna send the board some examples of what people are submitting as part of their subdivision applications. And in general, it runs the gamut of big majors to little minor subdivisions, because it's really what you will be seeing likely, especially in the south end of the valley, is a mix of different types of projects.
Okay. Back to you, Jenny. You're enumerated.
On a roll. Okay, this one's really petty. Page 43, second paragraph. The subdivider shall request in writing. Can he call? Or may he call?
That again is dotting the i's, crossing the t's, legal stuff that I think Nicole would agree with me, because I do subdivision review for places like the town of Circle, Shoto County. I mean, most of the time people will call up and we'll walk through it, and that's good enough. But there are those instances that if you don't have documentation that you have followed your regulations, and I can't emphasize enough that you'll probably sound like a broken record, is if you don't follow your own regulations procedurally, you'll lose in court for sure. So procedure, if you don't follow it, you'll always lose in court. From a substance standpoint, if you require a 100,000 gallon fire protection tank versus 75, that's probably not an issue. So I agree with you, Jenny. It seems over the top, and in general, I suspect Nicole is like me. It's usually a pretty laid back affair, especially with consultants we know well and trust. So it's entirely up to you if you want it to be in writing or a phone call. It's two sides of a coin, so.
So could we drop the in writing? Because yes, I agree with you. I mean, if they want something electronically or, if they email and request it, I guess that is writing. But can we just say, the developer may request it and then drop the in writing portion of that? Is that possible?
Yeah, I think whatever the board or the commission is comfortable with.
Okay. That would be my preference, because procedurally, I'm probably going to fail 50% of the time. If somebody calls and requests it, I would have a hard time saying, I need you to send me an email. Or I
No,
need you to
there's
send me
a
a
lot
letter.
of the stuff I think needs to be massaged, because part of what I understand what Jerry's saying, and I agree with part of it, it's just how we put it in the regulations. But we need to make sure that we have an established procedure that is followed for every subdivision, so that there is traceability
Right.
to it. So that if somewhere down the line, and it may not be any of the last 100 that you did, it might be 200 down the line, but if something isn't followed through and somebody with deep pockets and revenge on their mind, if they can go back far enough and find that it's not done, that's enough in court to make you lose. That's all I see both sides of the coin here. We just need to massage it to where it fits from a safety standpoint for the county and an ease of use, whether it's an email, just so that there's always a record back there. That's all I'm
Sure.
after. You know, a continuous thing that, yeah, we did this 15 years ago. Okay, it is what it is. It's just a matter of the fact that it gets done the same every time. So I think it's more procedural. I just wrote in there, I hadn't picked up on that one because I was kind of looking for this kind of input, but there's an awful lot of these. I'd be willing to bet that given enough time, we could probably have something in the margin by every third paragraph on the average that somebody had a question of or wanted some kind of comment on. I just think it's a good first step. So I marked it on mine, and then we can all think about it. I don't know what the commission has set for a timetable for us, but we definitely need more study in my mind before we can make a recommendation on it.
Sure.
Right.
On a lot of
Yeah.
these, I'm willing to, I just inserted that in case, you know, writing, the phone, just to check to maybe we left something out.
Well, like I said, that, to me, that's the kind of fine thing. Maybe it goes in the appendices, maybe it's just something that the county adopts across the board for all departments. These are the records that we're gonna keep. And at that point in time, it doesn't have to be in the regulations, it applies across the board to everybody.
Sure.
I don't care whether it's on the regulations, I just don't, first of all, I don't want the county to have to go to court, but secondly, when we do, I wanna win.
Exactly.
That's why we're here.
Now I'm getting into the technical stuff. Page 59, VC. The governing body may find land to be unsuitable for subdivision because of potential hazards such as flooding, snow avalanches, rock falls, landslides, etc. Now, when we lived up Ray Creek, every lot up there, you would not be able to build on any of those up there right now if this rule was in. 25-foot slope.
Jenny, I think the key word is may. It doesn't mean it's a must. I get what you're saying. I just don't know that you want to completely throw it out because I can guarantee you, you're gonna have situations where there's a piece of ground that everybody's just like, this is a bad place.
I agree with that, and I do, maybe we could emphasize the may.
Okay. That makes sense.
Because when it says down there, these lands must not be subdivided unless the hazards are eliminated or mitigated, design, construction. But all of those up Ray Creek, you have the creek and then you have that steep bank all the way. We had 10 acres and we only probably had 2 acres that was buildable. Okay, the next one, this one here, page 61. My book is totally marked up here, so you'll have to see if I correct on some of this stuff here. The horizontal, 1,000 feet to 10 vertical feet. If on this page here, you would probably have to eliminate Townsend. Now right up to the Ford place out here, as you cross the bridge, it's probably at least 1,000 feet horizontal. But 10 feet from the flood stage, is it? Maybe not. A lot of that, and we've never had the floodplain done specifically for this Townsend area. We've had it done for Three Forks, but not for Townsend. And we go by the floodplain maps at the courthouse on it for that. So every subdivision out there would be subject to a BFE study, is that correct? And why couldn't we just use the floodplain map instead of, now the A is okay, the whole paragraph of A is okay, but the complete and engineering study that identifies the base flood elevation, the BFE, this detailed elevation must be performed by a professional engineer licensed in the state of Montana, experienced in this field of work. That really is bad.
So, Jenny, what I would say is that I understand what you're saying about C, but I think you do, and that stuff can be reworked. That's specific to Richland County and Yellowstone River and the Missouri, specifically on their end, is I think you want to make sure that you maintain the flexibility that if you do have a piece of ground that there are photos or everybody knows is flooded, there may not be a floodplain map, that you have the flexibility to decide if you want to recommend that they do an analysis to determine if there's a floodplain. Does that make sense?
It does, but it just, I don't know, I just feel like you're giving people too much power in demanding this here, when we all know that common sense is a lot of the playing on this floodplain thing when you have the floodplain map. But like you say, if they come in with information and pictures that it has flooded, that maybe you could request it, that you may request it, but when I have to go through all this again here.
So that's what I would recommend is and that's what we did in Prairie County, and that's what Choteau County is talking about, is this actual section is reworking it so that you're either using an established flood insurance rate map that's been adopted, and then so the board knows, and you probably already know this, that the Jefferson River maps at the south end of the county are going to be coming up for public review. So either you're using a flood insurance rate map, or you require that analysis if there is clear evidence, whether it's photographs or, everybody knows that it's flooded and you have testimony to the fact that then you would require it. It's just not a blanket, because we all know you could be within 1,000 feet of the Missouri and it could be up on a wheat bench that hasn't seen floodwaters since the Pleistocene. So, as you said, Jenny, it's got to be a common sense approach to this. The floodplains that they deal with out in Richland County are way different than ours. They're bigger, a lot more water. They're especially in the Yellowstone, there are essentially no dams other than the diversion dams, which don't really stop floodwaters. So does that make sense? Is that an approach you want to do?
I can see that Phillips County has both the Missouri and the Yellowstone going through it. But in our county, we don't. But when I read this here, Missouri rivers where no official floodway delineation or floodway studies have been made, the subdivider shall do one of the following. And that one is to do the have a no-build zone, if it, the 1,000 feet to 10 vertical feet, and a complete an engineering study that identifies the base flood. So you would have to do it. It says you have to do one of the three.
Right, and what I'm recommending is that get reworked to be on a case-by-case basis, and it should be identified as best as possible in the pre-op meeting. Although you never know, when you go through the review process, a proposal could come to you and someone could walk in with a photo of a piece of ground under 2 feet of water, so. That's what I'm recommending is that just get reworked to suit the needs of Broadwater County, as this is written specifically for Richland County.
Okay.
And as Herb said, you're gonna get another kick at the can. This is not, I think Nicole would agree that the intent is not to go through this, draft something and push it through. You're gonna get to look at an updated, edited version, so.
Okay. The next,
Can I interject
oh,
one thing?
sure, please.
Jerry, we do have a floodplain, but I have some personal problems with it because they started at a random point and proceeded with extreme accuracy. Case in point, south of Toston, when you check the floodplain maps, there's a residence that shows to be in the water. You can stand on that property and look down on another residence on the other side of the river that's not in the water. And the engineer, it took 5 tries before he would admit that if you were to right angle the center line, the flood pool should be the same elevation on both sides at equal. It's not. So I guess my thought would be is, yes, we have one, but let's give people an option to prove it wrong, because we know for fact that there are places in Broadwater County where it is wrong.
Like Rendezvous subdivision.
Rendezvous is very close. It happens to be slightly upstream from where I'm talking
Yeah,
about.
and it's way up high.
Yeah.
If it floods, Townsend's gone.
Yeah. Well, Tom Helm's house is in the floodplain, and Hal Plummer's isn't. But you're looking down on Hal's house when you're standing in Tom's. So, you know, we need to use what's there. It's the law, but we need to come up with something in ours that has an option to prove it wrong factually.
Right. Well, if the board's okay, I'd be happy to take a crack at reworking this.
Well, but we're always open for suggestions, but, you know, Jenny and I have similar concerns that are not the same, but I think the whole thing is to make it defensible, concise, and
Just.
legal. Yeah.
And I do appreciate you going through this. We just throw these things out and then you can adjust it anyway. Page 62.
62.
B. No single lot may be divided by a public road, alley, public right-of-ways, or easements. Does not include irrigation easements, emergency access, gas, oil, or pipeline easement. Now, an example of that is across on River Road. The Missouri River is on one side. We own the lots there. And there are lots, and then you had River Road, and the gas line goes through it up there. Does that mean we couldn't have subdivided it because the gas line went through it?
According to this, you would have had to request a variance from the subdivision regulations, or yes, the lots technically under this requirement couldn't have been platted. You would have had to redesign the lots.
But you couldn't have because the thing went down the whole thing and you couldn't get over to them.
Right.
So that means your land's worthless?
No, no, that means that you may want to consider requesting a variance from the standard. I mean, there are good reasons not to make that a common practice, Jenny. I'm not saying that there aren't cases where somebody loses all economic value, but in general, you wouldn't want subdivisions that had all of that happening. And again, it's dividing the actual lot. If there are easements running through and the lots abut in the middle, that's different versus if you're splitting the actual physical division of a lot. Let's say I own 2 acres and you put an easement right through the middle of my lot. That's a de facto physical division of the lot, even though I own both sides of the road. Whereas if you could locate the lot so the road runs along lot lines, that's always preferable. But every case is different. So there may be an instance like the River Road circumstances where it may make sense. There's just no other option. So again,
We'll work with a variance on that one then.
Is that statutory? We're talking about B, right?
B, yes.
no, that's not
62 small
statutory.
b.
That's just
Yeah, small b.
best practice.
Okay. Because we have, in the past, we've had somewhat similar language, but we've had cases where the first one that comes to mind is up on the double power line, the 110 volt.
Right, down there
That goes
by
through, that splits.
by Watson's.
It went through, well, yeah, there's a whole bunch of them up there, but the idea being is that a lot of that stuff predates the subdivision. If you have an opportunity to work around it, that's one thing. But we need we need a little bit of flexibility there. And personally, I have a question even in terms of the irrigation easement, because I always bring it up that the easement, even if it hasn't been used, until it's physically abandoned, is still legal. And at that point in time, if you read most, an attorney would be the one to say, but anytime you're dealing with it, you have to have X amount of feet, not always enumerated, but you need to have physical access for a machine to get in, to maintain a ditch, to dig up a pipe or whatever. So I don't think we want to exclude irrigation easements like they did here, because that is statutory, that they don't go away.
Right.
In all practicality, they may not ever be used. But if the only way to make sure that happens is to go through a formal abandonment proceedings.
Agreed.
Yep, I would agree. It's might be easier to have an emergency access go through your property than an irrigation ditch or canal where every year someone comes through with a backhoe to clean it out, so.
Proceed, please. I'm sorry.
Number 6, page 65. This here, I really don't mean to sound silly. What is a half road?
So, back in the 1970s and the 80s, there were a number of instances where subdividers somehow got approved roads where they only had to build half the road. And this is one of those old things that's been in, I think it's in every subdivision regulations of the state. I think it's just trying to make it clear that you aren't going to build half a road. If you're going to build a road, you're going to build all 24 feet or 28 feet, not just one lane. So that's actually a really good question, Jenny. It comes up a lot.
I thought a half a road was, you had a subdivision here and a subdivision here, and they had half the road, they built half the road, so you had a whole road between the two subdivisions.
That's the way it started.
It is the way it started.
Mhm.
I thought they had one
We
down off
do.
of Wheatland Road.
Yeah, we do have some, we call them half streets, in the southern end of Broadwater County, specifically Wheatland Meadows subdivision. There are these 60-foot easements in Wheatland Meadows that are unbuilt, so that if the subdivision, what would that be, west, decided to, or if the ground, I'm sorry, west decided to, someone decided to subdivide it, they would have to align their streets to match up with Wheatland Meadows, and then they would have to build that portion of the road in Wheatland Meadows, is how it was written at the time.
And that's what I sort of remembered.
If it's legal, I don't know, but that's the way the condition was written at the time.
Right, so that's to make sure that you got an integrated road network.
Yep, correct.
Are they, would they be required to build the whole width of the road, Nicole?
Yes.
All next?
Yes, yeah.
Yep.
In the adjacent subdivision. So
Yep.
it really does, looking back now, you know, it's a good idea for this interconnectivity, but it's very limiting for the adjacent developer, you know, because he has to take into consideration now where those streets would funnel in, you know, because there's two of them on the west boundary, so that the east boundary of the new development would have to connect to that. So, you know, it could limit the configuration of their lots. They would have to configure their lots to align with those roadways.
Yep, they did, and they said a lot of it was because if a child was in this subdivision, wanted to play with a child in this subdivision, he didn't have to go out on the highway, he could just go through or up.
And, you know, we do that. We try to build interconnectivity into subdivisions now. I mean, the most recent one we did is like Vista, you know, with walking paths. But,
Yes.
building half streets is something that we did do, but I don't know that it's falling under this category of half, what are they called, half roadways.
On page 65 again, I got a bunch. 2 accesses. Now, when we lived up Ray Creek, the subdivisions, you couldn't have developed Ray Creek at all if you had to have 2 accesses. And I understand one of them is just for fire, because we built one down at Folkvoid that to go through their subdivision, it was just a trail literally to get through in case there was a fire, grass fire, whatever, to get through. But at Ray Creek, you have the road and Ray Creek and then the lot, skiddy lots, and then they're all 10 acres or 20 acres, but they go a couple acres on the ground and then the creek and then up a steep hill. Where would you put a second access or deny them to build that subdivision?
That's entirely up to the county to decide. I mean, you can only have 1 access, you can require 2, or you can deny it, you can do a variance. You could ask them to redesign it so the access is different. And you have a lot of flexibility when it comes to that.
There's only 1 access to it, and the only exit out is through Shindle's property up there.
And I think, you know, Jenny, it's a matter of scale too. I mean, if it was 3 or 4 lots, probably not a big deal. 400, you may not want to use that type of access.
Right,
So,
I don't think that, but
balancing out.
So maybe if we have the ability to take out required, can we say is recommended?
I don't think, I think you know, unfortunately, because this is a set of regulations, anytime you have may, could.
Yeah, true.
that-
Okay.
I think you'd want to pick a number.
That's true.
You know, if the board was, you know, if it's 10 lots or more, you gotta have 2 access routes, or 8 lots or more. I think you'd wanna have a hard standard so everybody knows. Just you get into the maze, coulds, woulds, and then it's just not pretty for you, Nicole, the board, or anybody, so.
That's true.
okay.
So we'll have to do some thinking on that as to,
Page.
because I can see where it would be beneficial. I think, Bray Creek is a good example. It's dangerous, but what do you do?
Right.
I don't know what you do. I mean, is it just,
You
does
pray
it
it
fall into
doesn't,
that undevelopable
Right.
category?
right.
Yeah. But if we mark that one for further discussion, we don't really have a solution for it at this point.
And on 65 also. These two are just, this is not a question. Note, approval of the subdivision plat by the governing body shall not be construed as acceptance of the subdivision roadways, right-of-ways, easements, or road system. Like Herb said earlier, the county would have to say they approve those roads, or they're automatically approved, aren't they, the subdivision roads when the plat is filed? Not that the county's responsible for them, but they approve that they are public roads.
So, a couple of things. Good point, Jenny. So what that language means, but it could be written better, is that the county is not accepting it into its road system. So to me, that should stay into the county road system. They should be accepted as public access easements, so anybody can use them, but it should be clear that the county's not accepting them into their maintenance system.
Exactly, exactly.
So if we just add into the county road system,
Yep.
okay.
Yeah, because down there on the note, it says the municipalities do not accept the responsibility for safety standards, construction, reconstruction, or maintenance of any road that is not officially accepted in the municipal road system. That sort of voided that all out.
Right. So one thing on 65, because Richland County works really closely with Sydney and the town of Fairview, that's why this municipal language is in here. I think you can actually delete those references, municipal roads, because if anything's gonna go into the city of Townsend, it's gonna be annexed.
Right.
That would be my recommendation, is any reference to municipal roads can just be removed.
I agree. We do have,
We have to,
well, we're working on an agreement with the county right now for plowing of an emergency route only within the city, but that's only just in the beginning stages, and that's only happening this year. So yeah, there's a very hard and fast line between municipal and county here between Broadwater and Townsend. So I think if we just eliminated that section entirely.
and then on page 66, just all of it county roads, all the way down. That's something you remember when Jeannie was in here, she said that's the one thing when we do the new subdivision regs, we positively need to address are the roads. So that's just part of the addressing it, to bring it to you all's attention. And same with B on page 67. And then on page 67 also, on C, culverts shall be a minimum of 18 inches in diameter and shall extend across the entire width of the roadway, including the side slopes. Culvert gauge depth and backfill shall be included in the design. Now, 18 inches, why 18 inches? Why not 19? Why not 16? Why not 10? Why 18? We just went through that with a subdivision. What was that subdivision out here where they put so much dirt on it? They said it was like a ramp when you took off.
Lake Vista
Lake Vista.
on Alaska Trail.
And so that's the only reason that this stuck in my mind were the culverts, because I didn't think he needed one that big. I know it went by how much water, but you could drain the lake through it, and the culvert was so big. How big was that culvert? 32 inches or something?
It's 36-inch squash. I don't remember the dimensions, but it's a sizable one. I can address part of your question. Any pipe, if you're going to require drainage, needs to be large enough that you won't plug it.
Right.
You can plug a 12-inch pipe with a lid off a 5-gallon bucket, or with a 5-gallon bucket.
Yeah, I just
I've
used
done
that
it. And you
example.
stick them in there
Right.
and then you make them hold water. So it has to be 15 inches or above, and the rest of it is based on what's commercially available. 15, 18, 21, 24, those
Right.
are available. Basically, it jumps, a 15-inch pipe's pretty hard to come by, an 18-inch pipe is easier. So it's 18, 24, 30, 36 essentially is what's there. You can get other sizes, but
Or put on there as required by the county road department, would that help?
no,
Yeah.
no, no.
What I would recommend on that is, designed and recommended by the subdivider's professional engineer, because then that engineer's taking the onus of their license that they have calculated that's the correct culvert size.
Okay, I go with that one.
15-inch or larger, if we're gonna hold a hard standard, it just needs to be 15 or up.
Okay. But not 36 if it's a little area.
That was DEQ, and don't get me started on that one. That was a whole
Okay.
different deal.
Page 68, this one's just a fun one.
Okay?
Traffic study. My 10-year-old great-grandson could count cars. Isn't that what they're doing? So why is an engineer required on A, B, and traffic studies A? Why do you need an engineer to do it?
So, the reason for that, Jenny, is if the county's gonna require the subdivider to build roads to a certain standard based upon the subdivision regulations, let's say it's gotta be an asphalt paved road, having a traffic study done by a licensed professional traffic engineer makes that defensible. If you just count, you're right, you could just have somebody count numbers, but the county has to have documentation from the applicant that what they're gonna require is legally defensible, and I think we would agree, a licensed professional engineer, while expensive, is more defensible than having my 16-year-old daughter count cars. So that's the rationale, is that whatever, you need to have the best data available to determine what type of road needs to be built.
Okay, got that. 72.
Can I interject here? I do not have a key to lock up this room. Jessica has that key, and she has done it 5. And I'm not trying to rush you along.
Oh, that's okay, I'm willing.
I'm just making that recommendation right now. It's 4. It just occurred to me when I saw the time up there. It's 4:22, and I don't have the means to lock up this building.
Okay, I'll talk
And I'm
fast.
not trying to rush you at all. I'm
You
just
can stand in the
putting-
doorway and keep people out while we go get the key.
The key is with the maintenance man who's home in Jefferson City.
I'll go fast.
I was not meaning to rush you. I just meant for purposes of putting a pin in it to come back to
Just
it later.
having fun.
That's
I
okay.
have no problem finishing my 5.
And I was not trying to rush you, Jenny. By any means.
No, I'm glad you told me.
It just, I had a moment of, oh shoot.
Page 72, real fast, C and D. Driveways serving more than one lot or dwelling shall not be longer than 660 feet. Why?
So my recommendation, Jenny, and the board is, unless Nicole has heartburn, I would delete driveways and alleys. You're never gonna see
Nope.
an alley. And this is one place where Tara and I disagree. The county the only business the county should have with driveways is requiring culverts. Getting in approach permits, you don't wash up roads. The county shouldn't be in the business of telling folks what type of driveway they want. If they want a dirt, as long as that lot abuts a road built to county standards, if they want a dirt 2 track to their house that's 20 feet long or a quarter mile, that's their business. That's just my take. So,
And do they need a turnaround?
Well, and there's no
Yeah,
way
I-
to do, sorry, I didn't mean to interrupt you. I think for driveways, there would be no way. There's no way to enforce that. We're not
Right,
requiring the
exactly.
developer to build the driveways. He's building a road. It will be the end user, the future lot owner, or the contractor that's building that driveway, but we're never going to come back and see that driveway. We're only going to see the driveway approach onto a county road. We don't even see an approach onto a subdivision road.
Okay,
So I think we should get rid of that section entirely, if it's possible.
I agree with Nicole completely. I mean, even if it sounded like a good idea, the county doesn't have the means to. As we talked about during the growth policy, once that final plat is filed, and unless there's money in an escrow account, it's done. So
Right.
trying to enforce driveways and alleys, yikes.
Yeah, I just don't know how you could do it.
gee, I think I'm getting near the end of the book.
Can I also make a recommendation that, going back to the county roads, can we call these subdivision roads? Or should we just make it roads? Let's see what page, I've got it.
I like it, I'm on page 66 of the copy that the board has.
Yes, there it is. Okay, I'm looking at it on my phone. Yeah, so,
I
because
like that.
in our county, we refer to, and I think it's just a matter of how we use the words. You know, they're saying municipal roads and county roads, but we refer to county roads as actual county roads, maintained and owned by the county.
Right,
And I don't ever want there to be confusion when we're using the term county roads in here, that these will ever actually be county roads as we refer to them.
or public roads, we can
Right.
refer to them as public
Or
roads.
subdivision roads, or something other than county roads.
Right. That's why I didn't think that, this isn't the time to go over that for us. Okay, I think I'm getting near the end. Two more. Page 105. Criteria for review. Any proposed use of a family transfer exempt divided pertains to remain tracts of less than 160 acres, as well as those tracts that were created before these exemptions. I'll go through those in a minute. Any proposed use of a family transfer exemption to divide a tract that was created as part of an overall development plan and such characteristics as common roads, utility easements, restrictive covenants, open space or common market. And a transfer of a parcel of land by one or more family members to another so as to prepare for a qualifying family transfer, followed by attempted use of this exemption. If grandma's living on there, we're gonna beat her up and make her get off of it. And then 4, any proposed use of family transfer exemption that would create more than one remaining parcel of less than 160 acres. Now, the 160 acres, by having been known something about surveying, it's rare to find a 160 acre piece of property. It's 159.99 or it's 158.2. You never, not in the 1800s and not now. It's rare to find a 160 acre. How could we print that, write it, get it across?
So you have the ability to determine what criteria you want to use, Jenny. So this is just criteria that's for reviewing whether, the reality is most people that are doing family conveyances, they want to give it to the kids so the kids can either build a home or eventually sell it and go to school or do something else. There are folks who simply use it to get around the law. That's just the reality.
Yes.
That being said, you have the ability to decide what the criteria should be for Broadwater County as long as it's defensible. It doesn't have to be any of this. This is what I would argue is best practices that have been used by other jurisdictions and reviewed by attorneys. But that doesn't mean it's the best thing for Broadwater County, so.
Yeah, I think the attempted use of this exemption That's what I have underlined here, scribbled. That one. Okay, if we're gonna go through that one. Page 106. The one here on definitions. The division must meet the agricultural definition as described in the definition sections of the regulations. It does not include gardening for personal use, keeping of house pets, or landscaping for aesthetic purposes. Now, if we have 10 acres like we have out on Jack Farm Road, that is non-profit, don't pay anything, and people used to be able to put gardens out there. You could put a certain part of it as a garden, Herb could take a piece of it as a garden, but that's not allowed because it's not sold, it's free. Same as if you had a big garden out there and you gave all the food to the food bank. Does that get rid of the definition of agricultural?
So I am going to the statute because I'm not going to sit here and lie that I know exactly what it says verbatim. So we're talking about agricultural covenants.
Do you guys need a blue book?
Oh, I got a book
Do you have
too.
your blue books? Or do you want one?
That one.
So the law does not define what an agricultural use is. All it says is divisions outside of a platted subdivision. I lost my place again, of course. I wish the law was easier to read. So a division is made outside of a platted subdivision by gift, sale, or agreement to buy, sell, in which the landowner enters into a covenant for the purposes of this chapter, blah, 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 provides that the divided land will be used exclusively for agricultural purposes. And then it goes on to section 76.3.211, which talks about changing the use. But if you decided that, gardening, a community garden met that requirement, that's absolutely fine. I think you just want to make sure the definition in the subregs says that.
Okay.
So we'll refer back to the definitions, because the state of Montana does have a definition of agricultural use for tax purposes, but the Subdivision and Plating Act does not refer to it. So.
Okay. Yeah, and that was the one thing I thought was wonderful, were all the definitions. I'll read that again. And then the same goes to page 107 on 1, 2, and 4, but that's all in that same category. One more. Exemptions 109. B. The proposed relocation, this is on relocations, creates a parcel of less than 160 acres, which prior to the relocation included more than 160 acres. Why do we have to take that out?
What page? I didn't follow you.
109, I'm sorry. I said the wrong
109
page.
at the top.
At the
Oh,
top, B.
okay, I was
B.
down at the bottom. Okay, I'm with you now.
When you have a relocation of the boundary.
You can remove that if you don't want it. I mean, I run into this all the time. I rarely deal with boundary line relocations that you don't have a tract less than 160, because like in Shoto County, the farmers and ranchers up there are dealing with such large tracts of land, they just file deeds for 160 and 360 and get things done. So if it's an actual survey that's being reviewed, the remainders are almost always less than 160.
I'm done.
Okay?
I bet you won't ask me to review another book.
No, I don't want you to take it as I was rushing you.
Oh, no, but I
didn't
mean,
that. No, I
take up the whole
appreciate-
meeting.
No, I appreciate your perspective.
So, Jenny, I would argue that this is exactly the type of review. Unfortunately, and I have my notes here, is unfortunately the subdivision regulations of every jurisdiction in this state, there isn't a lot of flexibility because they're driven by the statute. This Platting Act basically creates this framework that we have to work through. As much as people hate zoning, you have all kinds of flexibility to do whatever you want to do with zoning. The Subdivision and Platting Act is such that it's very prescriptive, so having someone go through it and ask these questions, they're the same questions that, mom and pop who just want to create one or two lots ask themselves all the time. So no, this is exactly those are the questions that need to be asked. Unfortunately, I have a friend who's an attorney who always says that if the contract's so complicated no one reads it, it's pretty much a useless contract. Unfortunately, we have to follow the law, and it's full of legalese, and it makes subdivision regulations very difficult to follow. So,
Subdivision regs are getting to be subdivision prohibition. They're cutting down on them. I mean, they're making harder and harder and harder to get a subdivision in on. I have two perspectives on that. One, I believe in property rights, positively, absolutely. When we were in Texas surveying, and I said to a guy building a subdivision, do you want me to go before the county commissioners and present this for you? And he says, present what? This is at Trinity, Texas. And he said, what do you need to present? I said, to get approval for your subdivision. And he says, if they're paying for my payments on this land, they can tell me what to do. I went in anyway to the commissioners. No regulations. We tell him where he has to hook his sewer up back in that corner, period. There's no subdivision regs where we were living. And the same, can you imagine Houston with over 4 million people, no subdivision regs?
They don't have zoning either.
No, they don't. Because they look at it like if you own a piece of trashy land here I'll give you an example. 1970s, a whole subdivision went in here. And over the time, it's got real rundown. Grannies died, children inherited, they rent it out, and it's rented out to just people don't take care of it. Got Jeep seats on the front porch. And he builds that beautiful new subdivision we put in right next to it. And you figure this is going to devalue his property. Instead, within 2 months, the first house had the Jeep seats off the front seat and the house painted. They were incented to bring up the subdivision, theirs, instead of letting his go down. And that's what they bet on. They bet on you're putting the money out to build this subdivision. If it goes bankrupt, you go bankrupt. If it makes it, you make it. And that's their whole premise. And maybe that spoiled me a wee bit. But I just feel like, and then the other part of me, I don't want any subdivisions going in because I don't want any Californians moving in. So that's where I'm torn at between these two things.
Gee, that's the first time I've heard that.
So anyway, that's where you all know I'm from.
yeah, I get what you're saying, Jenny. Relation with that, you guys probably saw the article in the Bozeman Chronicle 2 weeks ago. The fact that housing prices in the Gallatin Valley went up almost 30% a year,
Yep.
$100 in 6 months.
Oh, wow.
Yep.
But unless this is a bubble, wow, we're all in for, and I'm not making a judgment value. I live here, I have a house and that's another piece of property. It's just, we're in for a rude awakening.
I think we are too. Now, I will bring one last thing and I won't say another thing.
You're a liar.
Well,
I know this
but
about you.
I'll go to confession. The Pope, yeah. The priest is probably at church right now with
You talk
Bernadette.
as much as you want.
I would rather keep these regs right here, ours, and make a few adjustments to it than accept these. That's my personal opinion. And I have stickers on ours.
And you can do that. The only thing is, and I think Nicole will attest, there's a whole bunch of statutory changes that aren't in your regs that you do need to add, like phasing and a bunch of other things, to make sure that your regs are legally defensible. And that was the only rationale to use the Richland County regs. And you can always identify the things in the template that you don't like, and we can rework, or if they aren't in statute, take them out. I just didn't want you to have to go through the whole process of reinventing the wheel to meet all the statutory changes that have occurred since the last time. And that's the one beauty of the Richland document, is all the statutory changes are in there. And you don't have to be like, oh, have we covered our bases? You can focus on the criteria for family transfers, decide, what kind of road standards you want to have, fire protection standards. You can decide how you want to, if you want to recommend to the commissioners that you treat subsequent minors as first minors. You can focus on that sort of stuff versus having to go through the weeds about all the statutory changes that have occurred. So.
Well, I appreciate you all tolerating me.
I appreciate your perspective and your in-depth look at this, Jenny. I think that's very beneficial.
A general quick question. What form of government does Richland County have? Are they charter?
County commission, just like Broadwater.
Okay. Because there's some things in here that look more like they might have charter government where they could write their own rules, at least in mine. This one is just food for thought. Well, to get to that food, the fact that they're going through the oil boom, that's one reason I didn't make it all the way through it because I got too involved going back and forth. So I didn't make it as far as Jenny did through the standards. Did they put any provisions in here specifically because of man camps?
They didn't, because they have what they call a temporary workforce housing zoning regulations and building for leaser regulations. So Richland County, during the boom, adopted a zoning regulation to deal with temporary housing because they were having some bad issues. RVs dumping waste on the ground.
Oh yeah, I'm sure of that. That's the reason I asked, because I was hoping that some of that would already be in the subdivision regs. And one of my thoughts was to be a little proactive if it ever hits here, because when that kind of thing hits, it hits instantaneously. It doesn't give you, by the time you read about it in the newspaper, you've already had several violations, to put it that way. They just move in and go bang. That's the way the business works. Would be to come up with something, and you tell me if it's even possible, because I'm not 100% certain we could do it without legislative help. I think there needs to be something to address that, so that if an emergency situation arises, however it's defined, whether it's business, I don't care if it's a mine, if it's energy, anything else, DEQ still holds all the cards in terms of approval. But I think that we're all missing the boat, not just Broadwater County, but the state in general, if we don't get to the point where when something like this happens, that we can say, okay, you hand them this supplement and say, you do everything in here, you post a 1.5% bond for the total valuation of it, and if it doesn't meet, what's in there, then we're gonna collect the bond. Because it's business, they'll throw money at it. And it will happen. It's the time that leads to all the violations. If you gave an owner or a contractor company or whatever, something that was there and said, go buy a bond, you're gonna build a man camp, you're gonna do this, it's gonna be $12 million. Post a bond, they'll do it in a heartbeat and go to work before the ink's dry on the bond. We just need a means of making sure that they follow through with it. That's where the bond comes in. What led me to that was the deal on the construction timing down here. They were talking on page 15. In these standards, they talk about anything being subject to being redone or removed. Well, we don't have an appetite for enforcement. It's happened around here quite a bit. But if we had something in there, I don't have a problem with somebody going to work before the thing's approved. I just have a problem if it doesn't meet what gets approved or doesn't get changed to that point. If we made them post a bond, that's a very minimal expense to pick up. What's a major now? Like Horse Creek. You've had Horse Creek for what, 6 months? Longer?
Ooh, it's been a long time.
Hmm?
It's been a long time.
Yeah. The idea being is that to go through the process, if they've really got their act together, then we ought to be able to accommodate the economy for them to go to work, but still preserve what we're after, and that's the idea that they're going to do it right, and it's going to be done according to standards. To me, posting a bond is the way to do that, whatever the amount is. But I think we need legal help. Is that, I mean, legislative help to do that?
Yep, what you're talking about, Herb, in some respects, not exactly is what we would call in the business of development agreement, being able to enter into a contract, and in the case you're talking about is having them post a bond that the local government has access to the money to say, okay, you can start preliminary work, but we're going to go through review, but you're going to bond for this in case something goes wrong. We don't. True development agreements typically happen as part of the overall review process. You could probably, nuance something to do exactly what you're talking about, but we don't have the legislative authority. Tara Depew at Mako, Kelly Lynch, who's the attorney for the Montana League of Cities and Towns, and several other attorneys have tried there have been discussions in the last few sessions to try to create a development agreement system. It just hasn't been successful for various reasons. It's pretty common in a lot of other states. And a lot of these discussions tie back to phasing of projects and litigation on big subdivisions, particularly in the Bitterroot. But long story short, we don't have the statutory authority to do that. You'd get in trouble. Eventually, someone would, developer or NIMBY would sue you and you'd lose. So.
Yeah, no, I'm not saying it's available, but who do we need to talk to besides her to try to make something like that happen?
Well, it's hard to say. This session, while we're on the topic, this session, I don't know what's going to happen with land use. Between the budget, COVID, everything else, I just don't know how focused. I mean, there's going to be use legislation that passes. To me, it would need to be something that starts with Mako and the League of Cities and Towns, mainly because people like Kelly and Tara are the lead lobbyists for both those organizations, and I know both of them see the utility in a development agreement, particularly Kelly, and they're highly respected, they're really good at what they do, And if there are two people who could help shepherd that type of legislation through the legislature, it's them. I mean, obviously, there has to be a sponsor, senator, or representative, but I just don't know how high on their agenda that's going to be this go-around. Until we see bill drafts, I just don't know.
Well, I can understand that, but that, I'm planting the seed with you too, because just what you were talking about, the eyes of Montana will be opened. I've witnessed it in Arizona. I know how fast and how bad it can get, and if we aren't proactive and get ahead of the curve, all we can do is cry in our milk about what we should have done.
Complaint, yeah.
I agree, and I honestly think that's what's facing Broadwater County, Southeast Jefferson, Madison, and Park County.
In somebody's lifetime, there will be town from Livingston to Butte, north to Helena, continuous.
I completely agree. People think I'm nuts, and I'm like,
No, it will happen. We're still making people, we're not making ground until the man upstairs ends it all. That's what's gonna happen, because the old almighty dollar speaks.
Look at between Bozeman and Belgrade now.
Yeah, oh, that's just,
well,
believe me, that's not even the tip of the iceberg. That's just the point of the spear, if you will. One technical question, to going back to this, page 63 on, under 5G, under blocks, it says, in unincorporated areas, block lengths must not be more than 1,320 feet. An approved turnaround is required every 660 feet. Is that strictly Richland, or is there anything statutory? We've always had, we're at 1,320 for fire, and I think 1,600, and we've even waived that upon occasion for block length, depending upon topography. It just doesn't seem to make sense. It's more geared to flatland, small, dense subdivisions than what we have seen.
yeah, that's not statutory, Herb. Those are probably just number of best practices pulled out of somebody else's regulations.
Okay.
So, again, you as a board have flexibility to adjust those types of numbers.
There you go, Herb. Look at that. That was your Herb page.
Well, that's just one of the, there's all kinds of things there that
I even
No,
wrote
thank
Herb in the book.
find the other one.
Ours, in our current regulations, it says, unless impractical, block length must not be more than 1,600 feet.
1,600.
Yeah,
Yeah.
that's what I was thinking. The one that came up with is the one down there by Three Forks, south of Coulter's Run. Never developed, but we had that question. We're getting close on time. I want to ask you one more question, and this goes back to the legislative to see if we can do it. I'm thinking in particular, and it's going to be too late for this subdivision. I didn't reference it, so I can't find it, and I'm not going to take the time to look for it. Is there anything out there in terms of ADT on a roadway? Because I feel like there are places, I know for fact that there are subdivisions that are presented to be below, to maintain a local road standard. But with existing roads, existing facilities, it automatically takes that particular stretch of road over the limit. How can that be addressed?
So, well, if it's a PE, professional engineers doing the traffic analysis, they should be incorporating the exist numbers with the newly generated numbers. I mean, I don't know the specific cases. Anybody can pretend to calculate those numbers and say they're valid. I guess from my perspective is if you know the existing ADTs and you can add them to the proposed ADTs, I mean, you know, just from a practical perspective, you could use those numbers and say, listen, we get you're telling us that your subdivision's generating X, but we know the numbers on this road, and when we combine the two, it's over the threshold for whatever road construction standard, and you're gonna have to do X, Y, and Z. I don't know if I'm answering your question correctly.
Well, you're giving me ideas but it's not completely out of the realm like my previous question in terms of the bonds and getting stuff, because there's one going on right now that's gonna do this. I've seen it happen other places, but it's something that if we can legally get it in there, then I think we would be remiss in not addressing it, particularly if it's allowed by statute. We need to have specific reference to that type of thing in just to protect the county.
Yeah, I don't think because it's part of your review criteria, local services, public health and safety, that's the hook, is that it's just important that the regulations are clear what you require from the subdivider for the traffic study. That, for instance, it has, and again, this is up to you. Is it a professional engineer that their study not only incorporate the new generated traffic numbers, but have to take into account existing and, you know, make a recommendation based on the county road standards. You know, the language could be done that way, if that makes sense.
It makes a little sense, but I think because we are getting close on time, it's probably more like a phone call between me and you, and then to appropriate individuals once we figure out a plan of attack,
Okay,
to see if we can get the county covered on that.
that makes sense.
So, my Mickey's fast. I don't know about that
We got
one.
4 minutes. So next meeting, obviously 2 weeks from now, we're on to December 23rd, and I don't know that is a good idea.
Not unless you're bringing me a big present.
Yes. Yes. Once I stop volunteering for the county and get an actual. I'm just kidding. I tell my husband I volunteer here. So what is everyone thinking? I guess I don't know what your schedule is looking like.
Well, make another suggestion.
Or how long it would take to work on these. I mean, I guess I should reframe this question, Jerry. Do you have a thought process on this to maybe take these amendments that we spoke about today and send another draft out? Or what is your preference as far as moving forward? Or
I
methodology?
just sense that Herb and the rest of the board probably have more things they want to talk about.
Okay.
I think I would like to give you a full draft of all the changes rather than incremental, but I really would defer to the board. But my recommendation would be is we have another work session to continue this discussion, and that we could probably get through everything at the end of that work session, and then I can put together a reworked draft that the board can look at, and it's going to need additional changes, I'm sure. Does that make sense? Does that work for the board?
I
Yeah.
think so, yeah.
Okay.
And I would throw it out there that I'm always talking about the law, but we very seldom hold our meetings according to law, which means we have to have one in January.
Yeah.
Right.
Why don't we schedule one for,
Let's start
like,
off
say,
on
the
right
third
foot.
or fourth week? Give ourselves some time to get to this,
Okay.
but we need to have a meeting in January.
Yep.
What about January 20th is the third Wednesday of the month, or we can go with the second Wednesday of the month, which is January 13th.
I
Make
mean,
any difference to anybody?
no.
What
No.
does your schedule look like, Jerry?
I am wide open both the 13th and the 20th.
So let's do the 13th, and then that way it does give us an option for a 27th meeting. should we feel that's necessary. Even if that meeting ends up being just a conference call between the board, well, no, you can't conference
Okay.
call. Never mind, just Jerry can.
I don't have any problem with that, so we're saying,
13th?
January
13th.
13th at 3.
okay.
Okay, that sounds great.
Okay. Are we making it? Oh, we're over.
We're still close. She hasn't started locking the door out there yet, so I think we're good.
She's waiting.
Yeah, I know, she's probably waiting. We're almost done, Jess, I'm sorry. Okay, so now someone just needs to make a motion to adjourn.
I make a motion that we adjourn.
Approved?
Seconded?
Second?
Perfect.
All in favor?
Aye.
Thank you so much, Jerry. I appreciate it, and I hope you have a Merry
Thank you, Jerry.
Christmas.
And Jerry, I hope I didn't shake your brain up too bad.
No, this is
So you can
good.
stop the live stream.
Just as food for thought while we're still connected, I'm sorry, why don't we think about it like a 2 o'clock as opposed to
Okay,
In the stream. right?
3 so we have more time?
end stream.
Because this is a complex enough issue, I think we need,
Yeah.
particularly if we're gonna meet here, we need